cases before you. One also doesn't wish to create the impression that an in-camera application has been abandoned on the merits of it. And we are alive to what is happening both inside and outside this commission.
Yeah, no, Mr. Khan, you can't be asking us to make rulings on the basis of what's happening outside the commission. We've got papers in front of us.
Yes.
Before the incident of Sunday, you prepared an application and you were satisfied this meets the requirements for an in-camera application. You must have been convinced that you will succeed, right? Otherwise, you wouldn't have filed the kind of affidavit that you have filed. So you were confident, you and General Khan, before Sunday, were confident you've made out a case for an in-camera hearing. It doesn't take the evidence leaders to say you have not made out a case for you to say, well, I now need to do a new application, I need to supplement. It shouldn't even get there, right? When the evidence leaders say this application or this founding affidavit on its terms does not make a case for an in-camera hearing, you can't hold on to that and say, therefore, I'm entitled to do a supplementary or to be given an opportunity to consult with my client so that I get more. It doesn't work that way. You stand and fall by your founding application affidavit, and as you concede in your replying affidavit, you don't make a case. In ordinary circumstances, you would have been only allowed to introduce new matter that you couldn't have anticipated that comes out of the answering affidavit. Then you would deal it in the replying affidavit. That's not that kind of situation here. What we have here is you have pleaded certain headings. General Khan has pleaded certain headings and says this heading qualifies to be heard in camera. And there's quite a number of them. And the engagement with the chairperson, between you and the chairperson, is to say, well, on those headings, you haven't made a case for an in-camera hearing. That the evidence leaders take that point with you, because that's exactly what they've done. That they take that point with you does not create a door for you to say, well, I need to file another affidavit, and until then, you can't hear this application. This in-camera application. It just doesn't work that way. Effectively, what you are seeking is you seek to hold the hand of the commission in abeyance until eventually you are able to consult and get instructions from General Khan, whenever that will be, because that's effectively what your submissions is. Then we have this floating application, which is not being heard, which is not being decided, because you can't help your circumstances. Your client is in the position that you describe. And so we can't do anything about that part unless you can reach agreement. But in fact, even the agreement hinges on you getting instructions from your client. So we're pretty much in that same space. It's not as if it gets better. You know, when we say, if the decision is go and consult with the evidence leaders, you would still say, I need instructions from my clients. And you've described him to be in no position at this point to make to give instructions. So either way, it doesn't seem like the commission wins. You know, things will roll out in the way that we'll see eventually, but that cannot be. The point I'm making, or I seek to make, is we do have an application before us. If the final determination on this application is that a case has not been made out, then you must lose, or General Khan, the application must be dismissed if a case has not been made out. The evidence leaders have indicated what they consider in the answering affidavit as matter that doesn't require an in-camera hearing. You get the opportunity to address that. You may disagree with that, and that's a matter that will have to be determined. But they've indicated what it is that they consider not to be matter that qualifies for an in-camera hearing. If your application is dismissed and the evidence leaders are allowed to continue, or you agree with them that the matter that they've identified can run without an in-camera hearing, nothing precludes you from bringing a new application that now deals with other matter that you say warrants an in-camera hearing. You may even want to canvass the same topics, but this time with better information that is of assistance to determine that application. It seems to me that's the way that it can only proceed. Otherwise, we're going to be sitting in limbo for an indefinite period. And that does affect the workings of the Commission.
If I may have an opportunity to respond and to take an instruction from
Yes.
my attorney.